We are finally doing an episode that aligns with our channel name. Can employees get paid for work they perform after hours? Such as answering emails, responding to a boss's annoying texts or phone calls. In other words, performing services for a company outside their normal work hours. Before we get started, though, I do want to say that we thought we'd move away from COVID episodes while new regulations are relatively non-existent. But don't worry, we'll be back with breaking episodes if new COVID rules or guidance come out. How many of you have been asked to answer an email, respond to a text message, or make a call after your scheduled shift ends? How many supervisors out there have asked employees to perform work after they clock out? Did you ever stop and think, hey, should that employee get paid for the time spent responding to emails or answering a supervisor's call? Well, this episode will provide answers to this question. We'll also focus on providing information in this episode that discusses what to do if you do have employees performing work off the clock. So stay tuned if you're a company that falls into that category. So let's begin. The answer to this question is quite easy. But first, we have to ask, is the employee doing work after hours as an exempt or a non-exempt employee? Now, the answer to that specific question on exemption status is often complex and will take too much time to discuss in today's episode. But rest assured, we will be covering this topic in a future episode, so subscribe so you do not miss out on that topic. So assuming the employee's exemption status is properly classified, let's start with the non-exempt employees. The next question in the analysis is whether the actions being performed by the non-exempt employee after the end of their shift constitutes hours worked. That's the term of the day today. A determination of whether what is being performed is considered hours worked is crucial because the Fair Labor Standards Act requires that non-exempt employees receive at least minimum wage for all hours worked, regardless of the time of day that they're worked. Now, the straightforward definition of hours worked is simple. Hours worked includes all time an employee must be on duty or on the employer's premise. But there's a little caveat under the FLSA. Hours worked also includes any additional time the employee is allowed, suffered or permitted to work under that definition, regardless of the employee's work location, which of course could include at home. This means that any time spent performing services for the company, such as answering emails or phone calls for the benefit of the company, would count as hours worked. So that 15-minute email answered at 7:30 at night or that 20-minute phone call answered 40 minutes after leaving the workplace needs to be paid, even if the employee is not on the premise to clock in. If an employer is aware that tasks are being performed outside of work hours, or they should be aware that such work is being performed, then they need to ensure that this time is paid. Now, this also puts responsibility back on the non-exempt employee. If you're a non-exempt employee and you are performing work outside your normal hours, you need to report it to your manager or supervisor to ensure you do get paid. Now let's shift to what is not included in hours worked. Certainly, social conversations between employees that are completely unrelated to the company would not constitute hours worked. Employees meeting up for a non-required happy hour after work on a Friday would certainly not constitute hours worked either and would not need to be paid. In addition, there is a legal principle under the FLSA called the de minimis doctrine. This doctrine states that small amounts of time spent working, typically under 10 minutes, that are performed outside of work need not necessarily be paid. Essentially, for small amounts of time that are otherwise required to be paid but would be challenging to record falls into this de minimis doctrine. An example would be an employee replying with a simple yes or no to a supervisor's one-off text, or providing a quick 2-minute response to a follow-up question either in phone or email. Courts have established a test to determine if work time or hours worked is considered de minimis. The first principle that courts look at is the practical difficulty the employer would face in recording that additional time, especially those one-off couple-minute projects. The second factor looked at is the total amount of compensable time that's paid, and 3, the regularity of the additional work. Again, is this a one-off thing? Of course, de minimis time should not be a routine thing you employ, and employers do not want to find themselves trying to argue the de minimis doctrine in court. Now, there's one more important piece to this hours worked principle. That is overtime. If hours worked at home would put the employee over 40 hours in a work week, the employer must pay overtime wages of at least 1.5 times the minimum wage for that time. At the beginning of the episode, I promised you an analysis on exempt employees as well. So before we get to what employers can do to stop employees from working at home, I do have to state that this hours worked principle does not apply to your exempt employees. The time those employees spend performing services outside their scheduled hours would be paid in the form of their existing salary, and overtime wages do not need to be considered as those employees are exempt from overtime. So let's shift to what employers can do to prevent employees from working from home or outside of the standard work hours. It is important that employers communicate in their handbook and otherwise verbally or via email when required that non-exempt employees are not permitted to perform work outside their scheduled work hours without a supervisor or manager approval. We also recommend a similar statement for overtime work as well. This can also be communicated to individual employees as needed if you find that they're violating the written policy that's contained in the handbook. If an employee does perform work, including overtime, without prior approval, unfortunately, employers will still need to pay those wages, including the overtime, if applicable. However, the employee can face discipline for violating a company policy, obviously up to and including termination. Well, I really appreciate you staying tuned for this lengthy but very informative episode today. We strive to bring people practical advice applying the required legal principles. If there are any topics you would like to see covered in a future episode, please put them down below in the comments. In the meantime, check out one of these other episodes from us on your screen now. I hope you all have a wonderful evening.